clear set of rules for all of the stakeholders. That's very, very important. And the stakeholders here become the most important discussion point, the stakeholders being the landowners. And I think there's a really important consideration in this legislation on the property rights issue. And there are some clarifications on the property rights, and that's very important. And I just want to put first on the record, this is a memo that I received from the Ontario Real Estate Association, and I'm going to read what they say. May 7th, proposed changes to the Ontario Mining Act will strengthen property rights in Ontario, says the Ontario Real Estate Association, OREA. The Government of Ontario introduced Bill 173, the Mining Act Amendment Act 2009, in the Ontario Legislature last week after lengthy consultations. Pretty much everything I've said. The Government of Ontario took the time to get Bill 173 right, said OREA President Pauline Auger. The proposed changes to the Mining Act are important steps towards stronger, better defined property rights in our province. It's a quote. Now, here's some subtle differences, and I think this is very important to see how, when you get into the detail of the legislation, how important the strong words and clarity are for all of the stakeholders, whether it's the prospector or the property owner. Ontario's Realty are especially encouraged that the lands in southern Ontario where there is a surface right owner and the mining rights belong to the Crown. It's very important. It's a subtle, micro-level detail there. The resource rights really belong to the Crown and are deemed to be withdrawn from prospecting, staking, sale and lease if the bill becomes law. That's very important. In fact, it's worth repeating that if you look at the southern Ontario, that would include my riding of Durham. It would include pretty well everything south of North Bay, really. And southern Ontario, I'm going to read it again, where there is a surface rights owner. That's me, my property. Could be a farmer. Could be a large landowner. It could be the Crown itself that owns that green belt area. Here's the key, and the mining rights belong to the Crown and are deemed to be withdrawn from prospecting, staking, sale and lease if this bill becomes law. I go on to say Bill 173 reflects the realities of the Ontario's 21st century, and Ms. Anger explains, homeowners, and this is a quote, homeowners and cottage owners in southern Ontario should be pleased to hear that their property is no longer subject to prospecting and mining. This is what we've been hearing about with the important growth in the nuclear industry and the need to have uranium resources available. They are available in Ontario, and yet there was a kind of a rash of prospecting going on, which is a whole issue of how property rights can be impacted without the property owner even being consulted. The property owners in Northern Ontario, under Bill 173, put restrictions on the type of property that prospectors can enter without permission from the landowner. It also approves the use of map staking, very important map staking with land formations and geological formations and satellite tracking and coordinates, etc. And it's quite possible in modelling of land formations and potential resources beneath the surface that a lot of it can be done through remote, what we would call map staking. The new Mining Act encourages more consultation and dialogue between landowners and prospectors. Traditional methods of prospecting are often destructive to private property. Map staking moves the need to cut down trees, knock down fences, or excavate land when a prospector stakes a claim. OREA represents 47,000 brokers and salespersons and 42 agents, and it's important. That's just one of the stakeholders, and there are many more as well that have been consulted. And I'm